everyone. Thank you so much for joining. I'm sure more and more people will continue to trickle in. My name is Sadie Caron, and I am the Communications and Fundraising Manager with Hub Cycling. And I'm so excited today to be welcoming you all to our webinar. So it's for Make a Will Week, which you may know is coming up next week, October 1st to 7th, the official BC Make a Will Week. So we are so excited to have partnered with Richards Buell Sutton, estate planning lawyer Max S.J. Shilleto, who is going to teach us all about the estate planning cycle. So there's our nice little connection with the cycling community. And just a couple housekeeping items, of course. We did want to let you know that you can always use closed captioning and that there's the option to see the live transcript and to set your subtitles there at the bar on the bottom where you see the CC. You can also feel free to use the chat. We will be looking at the chat for questions. There will be a wonderful Q&A section at the end. So feel free to put your questions in there. They will automatically be sent out to everyone, but feel free if you want to send it just to me. My name for the event here is Hub Cycling Events, but as I mentioned, my name is Sadie. So feel free to put any questions there. And yeah, so here's how you can set it. So once you have the chat there, automatically set to everyone, you can use that little drop down to send it to Hub Cycling Events. That would be me. And I did just want to mention that this event was co-hosted by Hub Cycling and Richard Buell Sutton in celebration of Make a Will Week. And so I did want to just mention that if you are interested in getting more involved in cycling advocacy, after today, you might be interested in considering adding Hub Cycling into your will for Make a Will Week, which is coming up. Some other ways to be involved is to join a local committee in your neighborhood. So we have the site up there. We always love our monthly donors, so feel free to support Hub as a donor or join as a lifetime member, and you can join for as little as $10 and have that membership for your lifetime. All right, so those are my little items, and now I am going to pass it on to Max. Max, take the floor.
Okay, thank you so much, Sadie. I am just going to share my screen here. Go to that screen. Okay, can you see that okay?
Looks good to me.
Okay, perfect. Well, hi everyone. As Sadie mentioned, my name is Max Shilleto, and I am an associate lawyer at Richards Buell Sutton, and I work in our wealth preservation group. You may have seen in my post for this webinar that I'm actually getting married this weekend. And I didn't want to mention that because I'm pandering for your congratulations or anything. I just thought I should probably let you know because I prepared my notes for this presentation at about the same time that I was writing my vows. So I don't want anyone to be alarmed if this presentation gets weirdly sentimental or start crying at some point, because there's some overlapping themes here. But essentially, it's my job to talk to people about what happens after they die. I don't want anyone to get the wrong idea. This is a fully agnostic presentation, and I don't know anything about the afterlife. But my role is simply to help people set up a structure that ensures their loved ones are taken care of, and all of their stuff goes to the right people after they pass away. So our firm, Richards Buell Sutton, is the oldest law firm in British Columbia. We have 2 offices located in downtown Vancouver and Surrey. And one of the things that I think makes our firm really great and sets us apart is that we have a really robust estate planning and wealth preservation department that is dedicated to making sure your assets are taken care of. We have litigators in our group. We have family law lawyers in our group, and I'm incredibly fortunate because we have some of the most experienced and creative estate planning lawyers in the province. But I'm a lot cheaper than them. So if you're looking to get your will done, maybe the first email is to me. So our last managing partner had this really cool saying that I always have to practice in the mirror in the morning before I give a presentation because I've screwed it up a couple of times. But he used to say that we're not good because we're old. We're old because we're good. I think I got that right. But on top of all that, our firm has a long-standing relationship with Hub Cycling. One of our partners, David Hay, has this reputation as one of the best, not the best, bike lawyers in the city. And he also happens to be one of the coolest people in the world. I heard that he might be attending, so I had to say that. Oh, sorry. Yeah, so Make a Will Week is upon us. Essentially, I think the purpose of Make a Will Week is to give people a semi-arbitrary target date to start getting everything in order. For a lot of people, getting estate planning documents in place or updating their old estate planning documents is a really easy thing to procrastinate on. The vast majority of people who I meet with are either going on a big trip, or they just had kids, or they had a recent death in the family, or they had to deal with someone else's estate and they know how big of a headache it is to if everything isn't organized properly. Otherwise, for people who are in good health, making a new will or updating their old will is something that usually you'll get to when everything starts to slow down and you have a bit of free time. But the problem is, for a lot of people, sometimes things don't actually slow down and you don't end up getting to it. And the critical tool, which is designed to protect your loved ones in the event that something happens, often just ends up getting lost in the shuffle. So I have about half an hour to teach you absolutely everything you're ever going to need to know about estate planning. I tried to pack as much information into this presentation as I could, but I'm going to speed through a couple complicated subjects. Now, if you have any questions that I don't address during my part of the presentation, feel free to type in a question into the chat, or you're also welcome to reach out to me directly after this presentation, and we can talk about whatever issues you're dealing with. So I know a lot of people are allergic to lawyers and billable hours, but I'm a really big estate planning nerd, and I am always happy to have conversations about unique scenarios and planning opportunities and help people come up with relatively simple solutions to some complicated problems. So my invitation to you is, anytime you have one of those problems, you're always welcome to give me a call, and I'm happy to have a talk with you about it. So this slide, the reason for it is that I want, as we get started with this, I want you to think about your life on a spectrum. Assuming right now you are 19 years or older and you have mental capacity to deal with your assets and take care of yourself, you have this really important window of opportunity between right now and the date that you lose capacity to get everything in place for your estate planning, get your incapacity planning documents dealt with, get your will in place. And if you don't have that all taken care of before capacity is lost or before you pass away, then Premier Evie gets to decide who gets what. So today I'm going to be talking to you about a couple different things. I'm going to talk about your incapacity planning. I'm going to be talking about your estate planning. I'm going to be talking about some alternatives to traditional estate planning. And I've also added some additional considerations, which you should be aware of when you're thinking about your estate plan. So the threshold for testamentary capacity is a complicated subject, and I can't fully explain it in the time I have today. But for the purposes of this presentation, I want you to think about incapacity as the point when a person loses the ability to mentally deal with all of their assets and take care of themselves. It's obviously a very complicated web to sort out, and I know that there's fluctuations with capacity, having dealt with that with my own family. But generally speaking, the concept of incapacity is an important one to establish from the outset for us, for two big reasons. One of them is that it's the point when you can't really change your estate planning documents anymore. And it's also the point when your incapacity planning documents come into effect. So there are two main incapacity planning documents that you should consider getting in place before you lose capacity. The first one is an enduring power of attorney, and the second one is a representation agreement. Now, both of those documents do two important things. The first thing that they do is they appoint another person, and hopefully a couple alternates as well, to make sure that decisions are being made on your behalf and to make sure that you're being taken care of. They also provide instructions on how you want everything to be managed during that really vulnerable period where you're alive, but you don't have the mental wherewithal to take care of yourself. Some examples of that would be if you're in a coma, suffering from dementia. Sometimes we can even use these documents if you're selling a piece of real property and you are in Europe and you can't get a flight back to British Columbia in time to sign the documents, then you can use your power of attorney to have someone else sign on your behalf. But generally speaking, representation agreement and power of attorney are used for incapacity planning. The difference between powers of attorney and representation agreements are that the power of attorney lets another person deal with all of your financial decisions. So that includes dealing with your banking, investments, real estate, if you have a business. And the representation agreement deals with all of your medical and healthcare decisions. If you don't have a representation agreement in place, the legislation in BC for major decisions at the hospital or end-of-life care decisions, the legislation is actually pretty good. The doctors are required to consult with a series of people. So first, it would be your spouse, and if your spouse isn't there, then it would be your adult children. If no spouse or adult children, then parents, then siblings, then grandparents, then grandchildren, in order to make a decision on what happens, whether the plug needs to be pulled or whether you're electing to have an additional surgery or something like that. So for those things, you don't always need to have the representation agreement in hand to give the authorization to make those decisions. And as long as your family gets along and everyone knows what you would want to have happen in those situations, it's not necessary for that representation agreement at the hospital. Where representation agreements are really helpful is when your family members need to start making decisions about your long-term care needs after you've lost capacity. So that means where you're going to live after capacity is lost, and if there are people taking care of you and taking you to medical appointments and all that sort of stuff. So the representation agreement gives the people you trust to take care of you a document that they can hold up and say, I have the authorization to make this decision for this person. Now, if you don't have a power of attorney in place for your finances, real estate, business interests, it's a much bigger problem. People often assume that their spouse has an automatic right to take care of their finances and real property after they've lost capacity, but they don't. If you have any property which is registered in your name alone, not held jointly with your spouse, those assets are basically frozen until your family members can apply to the court for an order that says these people can make decisions on my behalf. That court process is very expensive, and it sometimes will lead to conflict among family members. So when you're doing your estate planning and you're thinking, let's make a will week, I need to get my will done, power of attorney is equally, if not more important than getting your will done. So make sure that you also have a really good power of attorney in place as well, and you've thought about who the alternates are going to be if your spouse can't act. It's a way cheaper option as well. They're pretty easy to set up, and it just gives your family the flexibility to make sure that they're taking care of you in the way you want to be taken care of. Now, after you have lost capacity, someone's been acting on your behalf, and then you pass away, the power of attorney and the representation agreement can be thrown in the garbage. They have no more power. The appointed people don't have authority anymore under those documents because you're no longer alive. So we get to the will discussion. Now, in order to understand how wills work, you need to know what I mean when I talk about your estate. I've said the word estate about 40 times now, and there might be some people who don't know exactly what that means. So simply put, it's all of your assets that are in your name alone, minus all of the debts and taxes that you owe on your date of death. You put all of that stuff into a big bucket, and your will sets out a series of instructions for how your estate gets distributed. So wills have a similar primary purpose as those incapacity documents I was talking about. You're deciding who's in charge, and you're giving them instructions on how you want everything to be managed and distributed. As long as you are working within the confines of the law and you have adequately provided for your spouse and children, your will is kind of a blank canvas. You can set it up how you want, and it gives you an opportunity to decide on the people who you trust to make decisions and manage and distribute your assets over time. They also allow you to appoint a guardian for any minor children that you have. You get to make decisions on who gets your stuff, and you can also set up some rules around how they're going to get your stuff. So on that note, when I'm meeting with clients, I always use myself as an example. And I know that if I was 21 and I got a $200,000 inheritance, I would have immediately gone out and bought 1970 Norton Commando motorcycle. And I have no idea how to ride a motorcycle at this point. And I probably would have spent whatever was left over at the Calgary Stampede. Now I'm a bit older and a little more financially mature, so I'd probably be a little bit more appropriate to receive an inheritance and make sure it's invested properly. But if there is someone who's a minor or in their early 20s, say, a good way of avoiding this risk of your kids going and blowing all their money on something dumb is setting up a discretionary trust that gives the decision makers that you've appointed the flexibility to make sure your children are provided for at that point in their life, and some flexibility to give them money for education costs, or if they're going to buy a house, or if they're starting a business. And then they would grow into a bit of financial maturity, and at a certain point they get to, you can essentially say, if they've gotten to 35 and they haven't figured out their financial maturity, then a lot of people say, well, I'll just let them have it at that point. But you can set up a series of rules within that trust. We also use testamentary trusts where you have a blended family situation, and you want to ensure that not only is your new spouse adequately provided for during their lifetime, but you also want to make sure that once that spouse passes away, or you could divide it between new spouse and children from a previous relationship. But it takes that money that's going to the new spouse, and it protects it against that spouse saying, okay, now I'm going to go and give this to my kids, or now I'm going to give this to my new partner after you passed away. It will say that it is held for the benefit of your spouse during their lifetime, and then it goes to your kids after that. There's also some really cool tax planning stuff that you can do depending on what assets you have in place. So, like I said, there's a lot of options when you're doing your estate plan. There's also some really cool tax planning stuff, or there's certain structures that we put in place with different trusts. But I'd say that about 70% of the wills that I see follow a really similar distribution structure. And that is, I want to give everything to my spouse, and if my spouse isn't around, then I want everything to go to my kids. Or sometimes it'll say everything to my kids at 25 or something. And this structure can work really well for simple, straightforward estates, but there's a lot more that we can do to maximize the amount of the money that's going to end up in your family's hands. So I often say, if you look at your assets right now, and the expectation is that your children are going to be receiving at least $1 million or more than that, I would strongly encourage you to chat with your advisor about what estate planning options are available, because typically the everything to spouse and everything to kids, it doesn't give you access to all of the planning opportunities that are available. So ultimately, you're going to want a will that achieves a nice balance between structure and flexibility. And I bring this up because when I meet with people, I often tell them, I can make the absolute most perfect will tailored to all of your circumstances and your family needs, and based around all the assets that you have. But I need you to tell me the exact date and time that you're going to die. I need you to tell me everything that you're going to own on that date. And I also need you to tell me all the tax attributes of those assets. And if you're going to be difficult and withhold that information from me, we need to set up your estate planning documents so they're flexible enough to allow your decision makers to do what they need to do to ensure that you're maximizing the value of the estate and getting as much of it into the hands of your family members as you possibly can. So if you don't have a will, it's okay. You're not a bad person. If you're a cyclist in Vancouver, you should probably think about getting one. But for context, I've been practicing estate planning for my entire career, and I honestly just signed my will the other day. I definitely should have done it before, but at the time, the only things that I had in my name were Honda Civic and a giant mountain of student debt. But now I'm getting married. We just bought a place, and we have to make sure that our dog will be taken care of in case anything happens to us. So the chart that we're on now says it sets out how everything gets distributed if you don't have a will. And you might be looking at this and thinking, this is perfect. This is exactly what I would have wanted anyway. But even if that's the case, it's still a lot more complicated to deal with the estate if there's no specific person appointed. And it's a bit more costly, the legal process. It creates more of a strain on the family if you're not leaving specific instructions saying, this is exactly what I want to have happen, and these are the people who I want to carry it out. And oftentimes it'll lead to some fighting among your family members, and you don't want that. So I started practicing in Alberta, and I always tell clients that it is way, 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 way better to die in Alberta than it is to die in BC. There's two reasons for that. First one is probate fees, and the second one is wills variation. So probate fees are essentially a 1.4% tax on the gross value of your estate. So basically that works out to $14,000 on every million that your estate is worth. And in Alberta, probate fees are capped at $525, whether you have $500,000 estate or $500 million estate. You're paying $525 either way. So thankfully, there's a couple ways of working around probate fees for certain assets, and I'm going to talk about that in a moment. Wills variation is the other thing in BC. And wills variation is essentially the ability for your spouse or for your children to look at the will and say, I don't think I'm getting enough. So I'm going to take this to the court, and I'm going to challenge the validity of the will. And depending on the circumstances, the court might vary the terms of the will in a way that are more favorable to that challenging spouse or children. So when we're setting up the will, we have to make sure that there's adequate provision for the spouse and children. Whereas, again, in Alberta, testamentary intent is protected a lot more as long as you're taking care of your dependents and your will is done legally and properly. The court says we can't change it. BC is a lot more flexible, so there's a lot of opportunity for those sorts of challenges. So on top of the traditional estate planning documents we just discussed, I wanted to let you in on a couple more secrets. I told you before that probate fees apply to the gross value of your estate, but that's only for assets that are going to pass through your will. There are some assets that will be transferred immediately on your death, and those assets aren't exposed to the 1.4% probate fees. So if you're going to be looking into these, some of these tools are really easy to implement. Some of them are a little bit more challenging, but just make sure you know the pros and cons when you're doing it, and you're consulting with your advisors. I mean, I'll talk about beneficiary designations right now, but If you have life insurance or a registered account like an RRSP or a TFSA, you can designate another beneficiary to receive those amounts, and those go just outside of your estate, and they're not subject to probate fees. But when you're naming one child over another as a designated beneficiary, and then you have a will that says I want everything split equally between my kids, then one child ends up with half of your estate plus whatever the proceeds of these accounts are. So you have to be mindful of that when you're doing that sort of planning. You also have to be wary of naming minors and making sure that there's someone to manage those funds until they reach the age of majority. So I'm just going to fly through these next ones pretty quickly because I'm realizing that I'm already 1 minute over. Like I said, I'm a very big estate planning nerd, and I get really excited to talk about this stuff. Another way that your assets can be transferred to individuals outside of your estate is to register them in joint names. And there's a really important distinction that you need to understand with jointly owning property. If you own property as what's called joint tenants, then that is ownership with a right of survivorship. So say I own my home with my spouse, and on title it says Max and Katrina as joint tenants, then that tells land titles that that property is going to transfer immediately to my spouse on my death. If it doesn't say as joint tenants, or if it says as tenants in common, then it means we each own 50% of that asset. And then on the death of one of us, rather than it immediately transferring to the other, it goes through the estate, would likely be subject to probate fees, and then be distributed in accordance with the terms of the will. So if you have a chance, if you own your home, look at the title certificate and see if it says joint tenants. And if it doesn't, maybe consider if you want to have that changed, because it's a helpful way of avoiding that 1.4% probate fee. Now, if you're doing this kind of planning with an adult child, it gets a lot more complicated, and there's other considerations at play. When you give that gift, you can't really give it back. So there's a lot more to think about when you're doing that with an adult child. But this is joint tenancy planning is a really good way of avoiding the probate fees there. The other really effective way for getting around both probate fees and wills variation also happens to be the most expensive, but it's a really cool strategy where you can take everything that you own on your own, or everything that you and your spouse own, and you can move it into a trust that's either an alter ego trust for me alone or a joint partner trust for me and my spouse. You can only set up these trusts if you're over 65 and you're a Canadian resident, but it's a good way of moving assets out of your name into another entity, and then you can still effectively use those assets as if they're in your own name. If you're setting up one of these trusts, the only people who are entitled to distributions of capital or income have to be only you and your spouse. But it's a good way of moving things out and not having to go through the formal will process. And this also, outside of protecting against the probate fees, if you don't have a will in place, you can't apply to the court to vary the will. So it's a good strategy for that kind of planning as well. Now, a couple other quick things that I wanted to mention. In your will, if you're a philanthropic person, or if you're looking for an opportunity to offset some of the tax bills that come up on your date of death, you can always make a gift to a registered Canadian charity. For instance, Hub Cycling And by making these gifts, your estate can claim the donation tax credit and allow you to reallocate some of the money that would be going to that you would be paying for taxes and reallocating it to an organization that you care about. You can also do this during your lifetime, and there's some really cool tax planning opportunities involved with charitable giving. The other piece I want to mention, if you have assets outside of Canada, you will want to have a will in that jurisdiction. And by assets, I'm talking mostly about real estate. So if you have condo in the States or vacation property somewhere else, make sure you have an American will or whatever jurisdiction that contemplates the existence of the Canadian will. So make sure that will doesn't revoke your Canadian will, because that's a problem. And if you have property outside of BC, you'll also want to have a power of attorney in that province, because a BC power of attorney won't work if you have a place in Canmore, or if you have a cottage in Ontario. You want to have a power of attorney there as well to help your family manage that asset if you lose capacity. That's kind of everything that I have for this presentation, but I hope that you have some questions, and I'd be happy to talk about them now, or happy to pick up the phone and chat with you after this as well.
Thank you so much, Max. I have learned so much, so I'm sure everyone here has learned as much. We're seeing lots of thank yous in the chat. So yeah, everyone feel free to put any questions you have in the chat. I do have a few here already. So we did have Jennifer, who emailed a question in advance, who asked, I have a will, it's very outdated. Some names need to be changed and added and assets updated. No real estate, no kids. Do I have to make a new will, or can I make the changes and have those changes witnessed or signed by a friend, neighbor, or a notary?
So you should update the will. There's a document that you can use called a codicil, which is essentially a document that says, I have a will right now, but I'm changing this paragraph to this paragraph. We do this sometimes in situations where we don't have another choice, but it's kind of messy, and it can lead to a bit of conflict in the estate administration process. So usually the cleanest approach is to just simply update the will. If you got that will done with a notary or a lawyer, my hope would be that if it's just a simple couple changes and you're changing names and appointments, then it probably shouldn't be too costly. But if it's a fulsome change and you need to kind of consider a whole bunch of different considerations, then you might want to just kind of start from scratch.
Wonderful, thank you. And then our next question was Michelle, who was, I think this was regarding representation agreements and temporary decision makers. What happens if you have no family and a disability?
So there's a government organization called the Office of the Public Guardian and Trustee that is sort of the last resort if care is needed and you don't have family members or friends to make sure that you're being taken care of. Depending on the assets that you have, you can set up a power of attorney that appoints a trust company. Like all the major banks have trust companies of their own. So RBC has Royal Trust. They all have various trust companies that they're associated with. There's also smaller trust companies that you can use. So it's a professional that you're paying a fee to make sure that everything's being managed properly. They do a really good job, but it's obviously a bit more expensive than appointing a friend or a family member. So that's only for the power of attorney. Representation agreement. At the end of the day, someone is going to take care of you. The government will make sure that everything ends up okay for you. But if there is a person in your life that would be helpful to appoint, I would really encourage you to consider having that person brought in with representation agreement.
Wonderful. And then our next question is from Jen, who said, thank you. And can an existing very old will be amended, or is it better to make a new one? And then there's a couple of follow-ups, but I'll let you answer that first.
So it depends what the very old will says. We have wills in our vault from, I think the oldest one is from like 1906 or something, and we're legally not allowed to destroy it. Sometimes really old, straightforward wills work fine. Generally speaking, the law has changed quite a bit with respect to estate administration. And in my practice, I do both the will planning with people, and I also deal with the estate after someone's passed away in the estate and the administration and applying for probate. And typically what I see with really old wills is they're like 3 or 4 pages long, and they don't include a lot of powers. And when you're not explicitly saying that my executor can make investments or loans or deal with certain disputes, you sometimes have to go through the court to get permission to do those things. And it's so costly for your state to have to do that. So if you have a will that's older and it still does everything you want, and you're appointing the people you'd still want to appoint, and you're giving everything to the people you want to give it to, just have someone look at it, like another lawyer or a notary, to make sure it has everything that it needs. Happy to take a look for you, but if you have a lawyer in place already, it's usually cheaper to go through a new person.
Okay, and that was the follow-up question was, is there a difference in cost to amend versus new?
Yeah, it's all like, it's kind of law firm to law firm. It really depends on the changes that you're going to make. Like if for some reason we had a client, an existing client who has a will that doesn't include all of the new powers that we've included over the last 20 years or something, it's not that much work to add in those new powers. So just doing a new will rather than doing a codicil and updating is it's not that much different. But again, it depends on what the fee structure is for that law firm that you're dealing with.
And then the last follow-up for that was, can the POA and or executor live outside of Canada?
They can, but it's tricky. There are certain tax consequences involved with appointing typically a US executor, because it creates a question of whether the estate is a resident of Canada or the US. And if the mind and management of the estate is in a different jurisdiction, it might be subject to different tax laws. It creates a lot of complexity from tax side. There's also some practical elements. So like selling real estate in BC, if you have a child in Florida, is doable, but it's kind of challenging. So if there's someone else that is equally or close to as appropriate of appointing, you might want to consider appointing someone closer to home. And with the POA and the representation agreement, decisions need to be made pretty quickly. And sometimes you need to go to the hospital to sign something. Sometimes you need to go to a certain financial institution, and there's ways of getting things done, but when you're dealing with incapacity, there's a lot. It's really important to have someone that's close to home.
That makes so much sense. Thank you, Max. Then the next question, I think we'll do a few more questions because we are going a little bit over time. So
I'll answer them quicker too. I think it's kind of my fault.
Yeah, and we can always send the questions to Max, who can then follow up if you want to send them to him directly. So the joint tenancy planning slide says a transfer is a taxable transaction. So if my spouse is joint tenant and I pass away, he'll have to pay tax on our house.
So there's a spousal rollover available for transfers between spouses. Again, taxes, there's certain considerations you need to think about, but generally speaking, you would rely on the spousal rollover, and those taxes would be deferred.
Okay, great. The next question. I have 2 Canadian adult children, one in the US and the other lives in Alberta. The US child is more suited and my preferred one to be my representative, financial and medical. How does one do that? I don't want my estate transferred to the US.
So one way of doing that would be to say, if you have one kid in the US, one kid in Canada, you could set up a structure where you're appointing your 2 children plus one other Canadian trusted family member or individual or advisor to work together to make decisions. So you would allow them to make majority decisions together. That would ensure that the input of the US child is being considered, but it also protects against the US issues.
That is great to hear. And we also had a question about Indigenous nations, how the laws differ, and do you know about or work with these laws?
I don't have a lot of familiarity with it, but I have friends who do. So if you have any questions about that, I can forward those questions along. I know that there are variations in those 2 different structures of law, and yeah, I'm happy to point you in the right direction.
Great. And what are your thoughts on do-it-yourself will kits? Are there some good ones, or should you always work with a lawyer?
Yeah, I mean, I'm obviously hugely biased here, but I think that you should work with a lawyer, because the will kits that I see are when they're not done properly and we have to do the estate administration, and there are all of these issues that we have to get through and we have to go to the court. I mean, if your assets are pretty straightforward and your family dynamic is like really simple, everybody gets along, like they can work, but more often than not, we see problems with them. And there's a lot of risk that you're taking on by saving a couple $100 by buying a will kit Staples or going to some online service. You can save a lot of money if you spend a little bit more upfront while you're alive. It saves your estate a lot of hassle in the future. So again, take it with a grain of salt, because I get paid when you come to a lawyer. But I would strongly encourage people to consider consulting with a professional when they're getting their estate plan done.
That's a very, very honest answer. I love it. And what is the cost of having a will made or an existing will updated?
Very slimy lawyer answer, but it really depends on your assets. There's a range. Some of the smaller firms do them for cheaper. Some of the bigger firms do them for a lot more. We are kind of mid-range, but given like what I was saying about how our estate planning department is so robust, and I think we have the 2nd biggest estate planning department in the province. This is what we do, and so I think we stack up like very well against the bigger firms. I can't really give a specific number, but relative to estate planning firms in the city, I think that we provide a really good bang for your buck. Sorry that's not an actual answer.
No, I had a feeling that I'm sure that it varies a lot. And then we'll do one more question. I'm so sorry that we're just running out of time, and I want to respect everyone's time, but we will put Max's email and contact information in the chat there. So please follow up. I'll put my info as well if anyone wants to follow up. What happens if my parents own a property in tenants in common, and if one of them passes away? Does the property need to be sold?
It depends what the will says. So you got 50% interest, assuming it's 50-50. It would go when one spouse passes away, it would go through the estate of that spouse and go through the probate process. And if the will says I give everything to my spouse, then that 50% can be given back to that spouse with some costs associated. But it all kind of comes back to what the will says on that. And on top of that, when you're making a distribution through an estate, depending on what the will says, you can make a distribution by liquidating all of the assets of the estate, or if there's a property, in this example where it's 50-50 held by the two spouses, you have this 50% interest in the estate, you could work with the executor to say, I really just want the other 50% back so I can continue to live in the house. So that's so yeah, most of the time you probably won't have to sell the house, but it depends on the circumstances.
Thank you so much, Max. Your expertise has been absolutely really informative, engaging, entertaining, and I've learned a lot, and I hope that everyone who has joined us today has learned a lot as well. I'd like to thank you all so much for joining us. Thank you, Max, so much for presenting. This will be recorded and sent out as mentioned in the chat. Please feel free to follow up if you have any questions. Our contact information is in the chat as well. And I hope that you all have a wonderful day. And I hope that you have a great Make a Will week now that wills are top of mind and that we've all learned so much more. Thank you so much, everyone.
Thanks so much.
Have a great day.